discovery by the department of that undisclosed amount by virtue of a survey, by virtue of any proceeding whatsoever, then it loses its character of being voluntary, and therefore I may be exposing myself to penalty under Section 271. Now, very important judgments that are relevant in this context are, earlier of course we had Shri, Supreme Court. After that, in 251 ITR, we have two judgments. 251 ITR page 9 and 251 ITR page 99. Both of them deemed 271 mercy. Both of them are rendered by the same bench. It's a full bench of the Supreme Court. The Constitution is Justice Barucha, Justice Agarwal, and Justice Vijay Kumar. And they give opposing conclusions. The only thing that we can possibly say is that in the case where they have agreed with the SSC, the rationale is not set out, they just approve the judgment of the High Court. They just confirm the rationale of the judgment of the High Court. In Madhusudanan's case, which is 251 ITR 9, they go into explanation 1 and they come to a conclusion that on the facts of that case, penalty is exigent. Now, the point that I want to make here is, in the second case, 251 ITR 99, Sunil Kumar Shetty's case, they specifically go into explanation 1. That is a case that is directly on the facts that we are concerned with now. There is an offer made of undisclosed income. The High Court takes the view that it is bona fide. There is an offer that is made, it is bona fide, we are going to just accept it, and penalty is cancelled. The Supreme Court says it is found that this offer made by the SSC is bona fide as per the requirement of explanation 1. And therefore, we do not find any justification for the levy of penalty. Just 2 minutes. Now you look at the recent judgment that we are now faced with in MAC data. MAC data, interestingly, does not consider 251 ITR at all. It is a full bench and MAC data is a division bench, but MAC data has been rendered without consideration of the full bench judgment rendered earlier. Notwithstanding that position, I am not on the fact that the division bench does not consider, non-consideration of a judgment does not invalidate. That is not the proposition I am on. I am on the fact that on the facts of MAC data, a specific conclusion has been reached. There was a survey in the hands of the partners. They found income that related to the company, and then after discovery of such data, the company makes an offer, and that is assessed. Then the Supreme Court says, very interestingly, is we don't know what an agreed addition is. We do not understand this concept of what is an agreed addition. That is what the Supreme Court says. So they come from a different area altogether. If they had looked at Sunil Kumar Shetty's case, where Sunil Kumar Shetty's case, the full bench says, we find that an agreed addition is bona fide. Therefore, there is some sanctity to what is an agreed addition. There are situations where an assessee does make a voluntary offer. Now, a voluntary offer is assessed. There are various situations in terms of which the assessee could say that that addition has not been made solely on the basis of the discovery by you, but I have in fact paid advance tax in the previous year. Please see the payments for advance tax. All this will show that there is some voluntary nature to the payment that I have made. So it is not solely on discovery. The aspect or the dimension of bona fide is not lost. That is one argument that could be taken. But on the facts of MAC data, they found that it is not bona fide. I wish they had stopped with that. I wish they had merely said, we find that it is not bona fide. We find on the facts that these were all details that were not produced to the department earlier, and it is only upon discovery in the survey proceedings that this addition has come to be made. That would have been perfectly fine. But they have gone one step further to say that we don't understand what is this agreed addition. There is no concept of an agreed addition under the Income Tax Act. So, my conclusion on this would only be that MAC data is not an absolute proposition. It does not lay down something beyond which one cannot see. In fact, we have the recent judgment of the Madras High Court in the case of gem granites, where the division bench has distinguished map data on the facts of that case. And they have come to the conclusion that map data lays down a proposition which is an age-old proposition, except for this observation that we don't know what an agreed addition is, there is no such concept. The rationing of the judgment is an age-old rationing, where they say that it is not bona fide and therefore penalty is to be levied. The High Court, Madras High Court distinguishes it and says yes, it may be applicable on the facts of that case, but not in the facts of the case before us now. Moving on. Case study number 6 deals with relief under Section 10B. Here I have raised 2 issues for your consideration. We have an entity that is set up in a DTA in assessment year 2001-2. The year of setup is thus assessment year 1-2. It commences production and exports from 2003-4 onwards, and it is converted into 100% EOU in 2006-7. So the points for your consideration are: what is the initial year or the year of commencement in order to arrive at the 10-year period to compute the eligible period of relief under Section 10B. Now, there is a circular issued by CBDT in this context, Circular 1 of 2005, that enumerates various situations, gives various examples for how one arrives at the period of 10 years. Now, one thing I was unable to find in those illustrations is, it is always taken that the year of setup and the year of commencement of eligible activity are one and the same. Therefore, in this case, if one were to apply the circular, the first year would be 2001-2, which means that for assessment year 11-12, I am not eligible for relief under Section 10B. There's a typographical error in this question. It would be assessment year 1-2 and not financial year 1-2. But if I were to take the view that this relates to a relief under Section 10B, Section 10B grants me a relief in respect of income derived from the activity of manufacture and export of computer software. So what should be reckoned as the basis to determine the initial year or the commencement would be the eligible activity itself. In this case, the unit has exported in 3-4. Can I thus take a view that 3-4 would be the initial year, which would mean that for assessment year 11-12, I would still be within the period of 10 years. That was the issue raised. In fact, this one we did not have a chance to discuss it on account of paucity of time. But I believe that we do have a case for the reason that this is a provision that grants the benefit. It is directly relatable to 10B. The eligible activity under Section 10B is not just the setting up, it is not merely production, it is production, manufacture and export. And therefore, to determine what would be the first year, one would have to take into account this eligible activity, this entire eligible activity. The second question raised by me is the definition of a 100% export-oriented unit in explanation 4 talks about any unit that is granted an approval by the Board of Approval. As a matter of practice, we know that when a unit is set up, the green card is issued by the Development Commissioner or is given by the Joint Director. And almost in no case was this approved by the Board of Approval till 2009, when this issue was raised up in certain assessment circles, I understand first in Maharashtra. The CBDT then issued a circular to clarify this. But that circular was of no help for the reason that it merely reiterated the position in the explanation, saying that once a Development Commissioner issues it, this Development Commissioner issues investigation and it has to be approved by the Board of Approval, and only upon such approval is the entity eligible to claim NB. In fact, this has been considered by the Delhi High Court in two judgments. One is Regency Creations, where they hold against the SSC. In the second judgment, in the case of Enable Exports, on the facts of that case, that SSC had, during the proceedings before the lower authorities, obtained a ratification from the Board of Approval. Therefore, the High Court concluded, saying that the Board of Approval has also ratified it. The claim under 10B is thus to be accepted. Now, only one point that I wish to make here is, we find in several appeals that are now pending before the tribunal, the department takes a ground, saying that this is not a ground that has been taken by the assessing officer at the time of assessment. It has not been raised by the assessing officer if he is called for the appeal process before the CAT appeals, but before the tribunal, because they are wiser on account of these judgments, they take the view that this approval is only a Development Commissioner's approval, it has not been ratified by the board. So what we are doing now, by way of precaution, by way of abundant caution, is to obtain a ratification in advance. And we find that as far as at least Tamil Nadu is concerned, we find that the Board of Approval has been sitting regularly and they have ratified all approvals granted in the past by Development Commissioners. One thing to watch out here is, we find in some approvals granted by the board, they ratify it with effect from their ratification. They say, we ratify this from today. It may be unintentional, because it cannot be the intention of the board not to ratify what the Development Commissioner has given. But be that as it may, that works against me, because it means that it is approved only from a later date, which means that next we will be facing reassessment proceedings for all the previous years. So, to ensure that you protect yourself in respect of the past period, including completed assessments, the ratification letter issued by the board should ratify the approval granted by the Development Commissioner or by the Joint Director from the date when it was first granted. This brings us to the last case study. This is the only case study that I included on international taxation. Again, for the reason that it is a live issue that is pending before various authorities, including the Authority for Advanced Ruling. Many of the participants have told me that the facts are so clear. In fact, the chairman also told me that the facts are so clear that I don't see a dispute on this. If the facts are what they are, then you should have no issue in convincing the authorities, whoever they may be, that you are entitled to the benefit of non-deduction of tax with respect to the income received on offshore supplies. Now, there is a history as far as this is concerned. As early as the 1960s, the position was clarified by the CBDT that in a transaction of overseas supply, where the entire transaction happens beyond the borders of India, the manufacture of the goods happens outside, the transfer of the property in the goods happens on high seas outside the frontiers of India. Consideration is paid by the entity in India to a designated bank account outside in foreign exchange. Then such a transaction of offshore supply will not be liable to tax in India. In position one, small change in a fact pattern that may happen today is sometimes the contract, one party to the contract may sign it in India. But in my view, that may not affect the position on taxability. Now, we have had the Supreme Court in the case of Ishika Vajima look into a composite contract. That contract contained a scope of work as far as offshore supply was concerned. It also included a scope of work for offshore services and onshore services. And the Supreme Court, on an interpretation of those clauses, said, we are able to see that the scope of work vis-a-vis offshore supply is a separate and distinct scope. All the parameters that I just enumerated before you have been satisfied in this case, and therefore this is a case of offshore supply. The entire transaction has happened outside, which means that there is no liability to tax. Come the judgment of the Supreme Court in the case of Vodafone. Now, why should this at all impact this position is a proposal that I would like to leave with you. It's a thought that I would like to leave with you. I am asking this for the reason that we have had 3 judgments, 3 decisions, rulings of the AAR, where the judgment of the Supreme Court or rationale in Vodafone is applied to a situation of offshore supply to say that one has to look through the contract and not look at the contract. My respectful submission here is that Vodafone is only inapplicable to the transaction that we are looking at now. It applied to a different fact situation. The questions and issues for resolution before the Supreme Court were entirely different, and one should not confuse the two. Now, we had occasion to present a very similar set of facts before the AAR very recently. And these were the questions that the AAR put us. First is, why should I look at Ishikawa-jima as being the final authority on this? Because after Ishikawa-jima, the law stands amended by virtue of insertion of explanation to Section 9. The 1969 circular has been withdrawn by the CBDT. So if one is to look at the entire fact pattern, does it not mean that the position today is different from the position that Ishikawa-jima was concerned with? No. For the reason that the explanation to Section 9 does not deal with offshore supply at all. If you look at the circular that has been issued, as well as the plain meaning of the circular itself, it is intended to address only services. Because the explanation itself says income derived from 9, 1, 5, 6 and 7. Interest, royalty and fees for technical services, and does not therefore impact offshore supply at all. The second question that was put was this. You have one entity situated abroad that is supplying the goods. You have the same entity maybe wearing a different hat in India. In this case, in the facts before you, it is a project office. But at the end of the day, it is one entity, though in 2 different avatars. Is this a legally acceptable distinction? Or does one have to look through this distinction? Is one question that the AAR asked. Because at the time when Ishikawa-jima was pronounced, Vodafone was not there, the concept of look at, look through was not there. Therefore, today, if you are looking at a composite contract, where you have one entity like in the case before you, outside India, supplying, the scope of contract as far as the non-resident is concerned is over with the supply, and then you have its project office in India taking over the aspect of services. Is there a nexus that is to be drawn? Is one question that was posed. In my respectful submission again, what we endeavored to point out was that it is perfectly and legally justifiable to wear 2 hats or 3 hats. What has to be seen is what is my scope of work and my role under that contract. If I am able to show that as far as the supply is concerned, I have supplied and I exit the scene, that is it. The problem with most of these composite contracts are there will be an overriding clause that will continue the liability of the supplier also till after the entire scope of work is completed. Will this in any way militate against the position settled by Ishikawa-jima? That is one question that I would like you to apply your mind to. And the last question that was posed was, you are supplying something. Now, without these supplies, can the rendition of services happen? Obviously not. So according to the AAR, the fact that there is a supply which is inextricably bound with the aspect of services means that the contract is something that has to be looked through. Again, in my respectful submission, every contract will have somebody supplying something which is used for the final execution of that contract. Merely because I have 2 different contracts or 2 different parties doesn't make the scope of work any less distinction. Merely because I have one contract and one party, though in 2 different avatars executing it, doesn't make it any less acceptable. discuss and be happy to do it. That's my cue to go back to my seat.
Thank you very much, Dr. Sumanth. It was excellent, not only the paper, the drafting the paper was also very good, covering a lot of complexities, but your reply was also very, very apt and very clear, and I think it is very, very good that it was also done exactly on time. So you have again that kind of thought is right, everything. And I now request Chairman to give his comments.
Thank you. I think your stomach will be more heavy than your ears. So I thought actually the sermon. And fortunately for me, and as I expected, Dr. Sumanth has covered the issues so exhaustively. There is not much left for me to say now. Whatever we want to discuss, we discussed earlier. And I will compliment her for that. I have always said that paper on case studies is like a Hindustani classical music. If you know, Hindustani classical music is the only form of music which gives tremendous scope to the singer because he can improvise, he can innovate between two suits or what is called shrutis. He has to follow only two rules. That he must follow the ragmala, that is Swarami of the particular raga of the singing, and he must be within the four corners of the mantras of the dal which he has selected. Similarly, a good paper on case studies gives tremendous scope for improvisation, innovation to the participants. And today was an excellent example of that. And the participant need not confine himself to the issue list, but he has to discuss the subject. So he can think of alternative solutions, he can think of other issues which are arising out of it, which all happened today, and which have been very satisfactorily answered by Dr. Sumanth. She is a doctorate in law, but she has handled queries and issues with the skills of a surgeon. She is a doctor all the way. Just a few points which you may or may not have discussed in your, because we visited the groups for a short time. In the first case study, there is a sentence that the SSC is engaged in manufacture of surgical inputs. So the first question that must immediately arise is, does it amount to a business? If it is a business, it is the course of achieving the principal object of the charity, or it is a separate business which itself is held under trust, and therefore 11th Korea applies. Constitutions will be different for this purpose. And whether cancellation of registration will be justified on this ground will largely depend on answers to these questions. Obviously, it appears that scientific research and surgical implements, if it is part of the charity, assuming that it is a business, it is the course of achieving the principal object of, and therefore it is not prohibited, and will not affect your claim for example. Second point introduced was about the capitation fees. Here, as she rightly pointed out, all these acts are state acts. There is no central act. So there is a decision of the Supreme Court. Now, the state act, there is a difference in the wording itself. For instance, here I think that we Tamil Nadu Act, but Maharashtra Act is slightly different. The difference is not only in definition of capitation fee, because in Maharashtra, capitation fee also covers a consideration for promoting to a higher standard, which is not there in Tamil Nadu. Now the question is that when the Act is enacted, it also provides for certain other consequences. For For instance, Maharashtra Act permits voluntary donations in respect of certain purpose. And the very concept of application fee, and that it is in consideration of granting admission. If it is for consideration, it can no longer be a voluntary donation. And procedure to be followed under the Act is, under the Maharashtra Act, that a gazetted officer will make inquiry, preliminary inquiries. Then he will submit a report. Then on the basis of that report, the state government may decide whether to file prosecution or not. The question for your consideration was, or should be, that if all the procedure is not followed, can the AO has simply decide that you have violated the Act? This basically procedure laid down, because in this case it appears, from facts it is not clear, but it appears that the state government has not taken any steps. My personal view is that when a separate act is enacted by a state, the authority concerned to decide whether there is a violation or not is the state or the authority appointed by the state government and not the executive office. Income Tax Act may be a central act, but you can't allege violation of an act unless the authority prescribed under that act itself has not taken any steps. And should not order first. As far as depreciation is concerned, as between 20.1, Bombay got 264 ITI 110 had already made that there is no double deduction. And the depreciation, which was considered, is not to be confused with depreciation in 32 or 56. This is on the reasoning that a prudent trustee has to provide for it. It's a charge on profits. You cannot conceive of profits or income without providing for it. And therefore it has been allowed. So it has nothing to do with escorts or any other case. Double deduction on the provision of section 35 itself. Personally, I feel that this calls for a very strong case for amendment of law. I had given one suggestion about 10 years back. When we were asked to suggest ways for redrafting, when the director of court came, etc. I had said that why do you look at how the charity earns the income? You look only at the acquisition of income. Has full control over the acquisition. From whatever source they derive, so long as it is applied for charitable purpose, the government has not to worry about it. It was not accepted. Not only that, now we have a ridiculous provision of taxing the anonymous donations at 30%. You just think about it. Whether the donation is anonymous, how do you decide the donation then? People have a habit of putting money in the offer box. There are people, I was a trustee for some years, as you may have seen. We used to get lakhs of rupees per day in the offer box. You don't know who has deposited, how much he has deposited. There will be 2 rupee coins, there will be 2 rupee notes, there will be 100 rupee notes or 1,000 rupees. But so long as that money is utilized for charitable purpose, obviously there was no dispute. Why should there be a tax on it? Therefore, I have a strong belief and chamber that we can take some steps to suggest that the entire structure of taxing charities should be changed, whether they hold shares, unless it is used as a controlling interest, they don't offer any tax concession for it, that's all. But it's made so many provisions, and there is so much conflict, as I pointed out, Pillars 1, 31B, and charitable purpose. Take 12.3 also. See, it has inherent limitations. Registration was granted. Why was it granted? Because at that time the CIT was satisfied that the objects are charitable. The 12.3 is only can happen when subsequently it comes to notice that the activities are not genuine. The word genuine means not intended to be acted upon, not what you don't like. It is not intended to act, and it is only faked. It's only a ruse in the name of charity. Or your activities are not in accordance with your objects of the trust. You have the only two limitations. Like we say, and Mehra pointed out yesterday that escape income can be assessed. It will not always escape income. You have to satisfy the jurisdictional conditions. So 12.3 cannot be invoked per se. It is only for these two reasons that that 1233 can be invoked. Third point is, what is the date? Sierra Technical Engineering Society decided that first they made a statement is not retroactive. They will say, but that does not mean that something which has been done earlier to the amendment, if it is cancelled after that date, can be considered retroactive. But that case was left issue open. Apparently, Tamil Nadu decided that from what date the cancellation will take. It cannot make effect retroactive, that we can't be open the elections, we can't even register. We will apply to pending license also according to minimum. And this issue, I can tell you, is pending with online or something. I already tell you that Sierra does not decide from which date the cancellation will be operated. And to which assessment it will apply. That will be the High Court will decide. There is a second about the infrastructure facility. And as you know, special bench of the tribunal in Bombay, in meeting party elections, they held that infrastructure facility cannot be a part of the facility. Which was obviously wrong, because we cannot expect any person, any developer, to complete the entire thing. And this was taken care of by heavy justice, which is one of the finance elements, where they say that infrastructure facility can include part of the facility also. Now, confusion was confirmed by inserting the expression. It was inserted twice, and at both times it is not very clear. Finance Act 2007 had put one expression. Now, the present expression reads, which is against the clarification, that nothing in the section shall apply in relation to a business referred to in subsection 4, which is in the nature of our contract. Per se, first contract is not prohibited. It has to satisfy what it means in the remedial case. If you compare it with the earlier expression, which was inserted by Finance Act 2007 retrospectively, it was much simpler and easier to understand. That expression says, nothing in section shall apply to a person who executes the work. This is what the legislature intended. That only a developer of infrastructure facility should get this benefit. A person merely to execute a contract. I mean, on principle, why it should be denied, one cannot understand. But that is at least understandable. Present expression, you cannot comprehend at all where it will apply. Because it deliberately says, enter into a contract with anybody, with the central government or state government. Infrastructure facility includes rail system. You tell me who will go to construct the rails without any permission, without any. Under the Indian Railways Act, it is only the government which can own the rail system. Nobody can. So it has to be under government. Therefore, such sections, which are incentive sections, are not only to be interpreted liberally, but they have to be harmonized with the object and also humanized to some extent. You can't expect impossible. That's what Bombay said in heavy industry. So that was the case only when the jetty was constructed and some cranes were supplied. So it is essential for completing that infrastructure facility. And therefore, they said he also will. That's how the law will have to be interpreted and harmonized in future. Then in third case, well, I asked her this question yesterday, that it was not clear to me that we are not talking of demerger. Which are the two undertakings which we are talking about? There is a reference to mall and real estate business. Both can be separate businesses. But are they undertakings? Even today, you use the word demerger of assets. My point to her was that the demerger must be of an undertaking. Not a combination of assets does not constitute an undertaking. So can you spell out a demerger of this? Of course, the group discussion was very good on this point. They have come out with different interpretations. And I must say, I entirely agree with all the answers which she has given. I am not differing from the answers. But one more aspect we have to consider is suppose the demerger is not tax compliant, but is at book value. Then what are the implications? You will find that except in respect of carrying out of losses, there may not be any tax incidence at all. It is highly parcel which is not taxed on land but which is made an value will not attract any tax. Consider next time this issue. Then about the agricultural land, there are so many decisions and so many reasoning given, and you cannot reconcile them. So as Supreme Court has said on this, the Supreme Court will decide this issue as satisfactorily as I try to find reasons. But one decision I found very liberating was of Gujarat High Court in CIT versus Siddharth Desai in 139 The crux is correctly summarized by Dr. Sumanth. But some operations have to be carried out. There is a location of that land. It is surrounded by other houses, etc. It will not become irrelevant. And then you have to see the context in which the word agricultural land is used. Because it is used in 214 for income tax purposes to defer declining capital asset. It was used in Wealth Tax Act. And section 54B, if you have noticed, does not use the word agricultural land. It says land to be used for agricultural purpose. Now, whether this phrase, land to be used for agricultural purpose, is wider and takes into account some land, it may not be called agricultural land. How do you reconcile and also the purpose of having two different conditions in 54B and section 240? Then, about the penalty, I discussed with her yesterday also. I am not aware whether the group had taken into account provisions of section 271 AAA and 271 AAB. Because now they have made a dent in the law which was understood till then. And still impose penalty even if the disclosure was voluntary. And prosecution file of 132. So that protection, one of the queries raised was whether the protection to what extent is available. That cannot remain much relevant after the introduction of these sections. But I entirely agree with the view expressed that you cannot stop at your agreement. You have to further. In some case, the Supreme Court said that Sarina's were is overruled. But in the entire decision overruled, only some aspects. Because one of the observations is Sarina's were was that there will be 1,001 reasons why the expression was not accepted or why the expression was not properly published. But that automatically leads to the conclusion that the amount requires concealed income. Concept of concealed income is altogether different from mere addition, mere agreement. And I don't know from where we get it, but I have seen several statements recorded during the course of search, where he said that to buy peace, I am against this. However, I made a distinction between a confession on point of fact in 68 area, in the context of your right of appeal, and confession on the point of mixed question of fact and law, or question on point of law. Confession on point of law. We had a case recently where, in the course of search, the Marine Act was made to agree that entrance is received by a social income by the arrival protest. This issue was covered by Aristotle, and he mentioned in statement also. Now, these type of statements can never fall or never qualify for any review of any penalty, because there can be no stop or point of law. So it's a very question of fact and law also economic. And confessions on fact or agreement on fact also can be revoked or can be taken into fact, provided it produces sufficient evidence, which also happens in many cases. So it is not a straightforward question as to whether penalty can be levied on the agreed actions, but you have to go deep into the question as to whether it represents is there evidence to show that it represents concealed income. Then as far as the case study number 6 is concerned, one of the questions which came in my mind is whether the facts which are stated say this is the rate of manufacture. Because what is stated that the unit was set up in 1-2 and the export was made in 3-4. What happened during the gap? We know that there is an interval between setting up of business and commencement of business. And the time period of 10 years starts from the date of manufacture of software rather than setting up of export. When you export, obviously you have to presume that manufacturer has taken place. But is that the first year? Whether any local states, whether any manufacturer which are manufactured but not found up to the mark. So what will take a commercial manufacturer? Because they are considered a commercial manufacturer, whether it should be brought in or not, like we did in 88, is another question to be decided. But as far as the approval etc. are concerned, these are matters so long as the government being, which is currently concerned with it, has approved it. The fact that a particular authority has not approved it should not come in the way of granting exemption. So long as that authority has acted on assumption, that is the validity status and validity. As far as the period of concession is concerned, you may refer to CIT versus Malawi Spinning Mill in CIT 353, which I found was a good development of this issue. Lastly, about the international taxation. More often I feel that the issue cannot be applied out of context. More often the issue involved for entirely different. It arose in the context of capital gains, and the business which was in India was considered as an asset. And that is how the amendment came in 2014, and that is what relevant as amendment 59 for deciding this issue. According to me, as far as supply, it was verified that whether the issue raised related to supply of materials, related to supply of materials, all these things can be relevant. And whether it was permanent establishment or not, is a question of fact. And as you are aware, in none of the tax treaties, the word permanent establishment is exhaustively defined. It is always inclusively defined. But two words which permit all this cannot be forgotten. One is permanent, and second is established. Permanent, how permanent it should be, for construction orders it is defined that it should be more than 90 days. But otherwise, establishment also has a meaning, and more importantly, income is taxed at the stage of approval. Subsequently, what happens cannot be relevant for deciding the tax rate. That principle also has to be borne in mind. And therefore, I feel that the question as raised, but she pointed out that they are raised for a particular purpose and because of particular view, which are already taken, not being relevant. So, this is our discussion. So, friends, at the end, I have not only happy complimenting Dr. Sumanth, but also to all participants, because they really add color to the discussion. And I have there, in fact, I told her that I would like to say only 2 words at the end, thank you. The first one points she had covered so well. But now I will say again the 2 words at the end. It is more evident. Thank you.
Thank you, Shri. In fact, you all know Shri is a veteran in this field, and every year, every RRC, you always want to him to chair at least one of the sessions. And again, done a good job, sir. And now it's time to thank and compliment our group leaders who have done a great job. And I would request or ask Mr. to please come and do this. In fact, our group leaders, Shri was Chennai yesterday, and all the group leaders had a meeting with the paper writer and the chairman till almost night 12:15. So very good job, so that the group discussion becomes very lively. Mr. Harish Shri. Rajendra Mahajan. Mr. Vipin Karani. And our Vice President of Chamber, Mr. Bharat Savla. And we also acknowledge the efforts of the group mentors for today's paper. And one of them was our past president, Manoj. Please stand up. Other group leaders, we have two Deva, and Siyam Babasi. And now request Hinesh Joshi to make some announcements and propose a vote of thanks.
Friends, a few announcements. The venue for the lunch will be at Laview and Chembur. Immediately after the lunch, we will go to Mahabalipuram. All those who would like to join should send them within the next 45 minutes. Ideally, we would like to start around 2:15. Light refreshments and tea will be served at the Mahabalipuram. Dinner will be served around 8:15, and immediately after the dinner we have a very spectacular program of Antakshari, which is hosted by Mr. Joshi. It's a treat. I request all of you to come and join the Antakshari program. Same venue. Tomorrow the group discussions will start at 8:45 a.m. immediately after the breakfast. Venues are the same, there is no change. As regards the departure on last day, which is Sunday, all those who have registered, and the flights are between 5 and 6 p.m. The bus would start at 12:30 p.m.